Izac-Hassan, you are most welcome, and we are privileged to offer you the microphone to engage with us. Thank you so much.
Recording just started at the time that we're about to start, which is great. Thank you.
Brilliant.
Thank you, colleagues. This is a privilege to be able to share my insights from my research work and my thoughts with you all, and hopefully get some good feedback. So I'm looking forward to this time. May I just make a quick correction that I am a teaching fellow at SOAS, not a lecturer. Just needed to make a quick correction. Right, so I'm going to be sharing my screen with you. Please let me know if you can see my screen. Can you let me know if you can see my screen or you still see me?
You can see the screen, we can see your slides.
Oh, great. So you can see the slides now. Good. So, negotiating with the enemy, contextualizing ADR in Ghana's criminal justice system. The enemy. When I decided to present this paper, I thought, how best can I share my work with colleagues? How best can I put across insights gathered from my work, and which would enable us leave this platform with a fair idea of what my work is and my proposals moving forward. Right. The criminal justice system is, hold on, I think my screen, yes, that's better. The criminal justice system.
So just as a 200 mile,
feedback, sir. I just wait. Great, right. The criminal justice system as we know it is adversarial. Hopefully, we've not had to be involved in it, but one way or the other, at a point in our lives, someone we know, if it's not us, will be involved in the criminal justice system. It could be England, Wales, or even in Ghana. So it is necessary that academics pay attention to what goes on in the criminal justice system and, as it were, carry out valuable research to ensure that Ghana keeps up with modern practices. Right. So this is just a roadmap of my presentation this evening. This is where we'll be going. So let me start by talking about the parties to an offense. Now, whenever a crime is committed, there are parties to the offense. I'm sure if I asked, what most of us would say is the offender, the victim, yes. And sometimes there's a party we don't talk about, the community. Now, each of these parties has rights which need to be addressed, hence the criminal justice system. It is set up to ensure that these parties whose needs have been, for want of a better word, infringed, or whose needs have arisen as a result of a wrongful act by one of them, should have those needs addressed. That is the purpose of the criminal justice system. Now, the question is, does this always happen? And that is what I will be talking about today. Whether or not Ghana's criminal justice system addresses the needs of all these parties. From the top of my head, I would say not really. But let me just take my time and walk you through my presentation. Right. So like I said, these three parties minimum are affected by the crime or the offense committed by one of them, the offender. And we all know the offender is the person who is, alleged to have done something wrong. The community are the rest of us who are watching. But I want us to look at the victim. Basic definition would be the person who has been affected by the wrong committed, yes. But there's something interesting which I'd want to draw your attention to. It's not just the person who has been affected directly, the victim, but also it involves the family or dependents of the victim and other persons who may have stepped in to intervene or assist the victim. All those parties have needs. All those people are victims. So yes, if we haven't thought about it today, sometimes the victim is not just the person who's had their property stolen or economic loss. No, sometimes they are indirect. Other people have been indirectly affected when they stepped in to help the victim. So when I talk about negotiating with the enemy, it's not just the person who has been affected directly, but all the parties at a point in time will be required to negotiate or to sit down and talk. Right. So ADR, I'm still trying to break down my topic. The topic is negotiating with the enemy, contextualizing ADR in the criminal justice system. ADR, most of us understand what ADR is. Basic definition, any process outside of the common, the court system, the formal court system, which is used to adjudicate cases. Basic definition. So if we decide to refer a dispute before the court to be settled outside of the court system with or without supervision of the court, that's ADR. Basic definition. I'm not going to go into technicalities. And some of the mechanisms would be mediation. The parties meeting to talk with the help of a facilitator, a mediator, or arbitration, similar to that. Arbitration also has its rules, or negotiation. So they can be placed within the formal justice system or operate outside of it. That is ADR. So when I talk about, or when I suggest that we should be thinking of contextualizing ADR, situating ADR, placing ADR, does ADR have a place in Ghana's criminal justice system? That is where I'm going with this. Right. Conflicts always occur. I mean, in our homes, in our businesses, in our workplaces, there's always going to be conflicts because we're human beings. We will not always agree on, the best way to carry out things. And because conflicts always exist, there has to be a way to address these conflicts. Hence, the formal justice system. What is the formal justice system? The traditional courts, as we all know. And what do? They emphasize the rule of law. What is the rule of law? The law is supreme. No one is above the law. Some of the examples, the transparency of the law, access to legal remedies, legal certainty, precision. We need to know the law. So the law is supreme. Let's just say rule of law means the law is supreme, basic meaning. Now, because of the rule of law, because of the principles underlying the rule of law, our formal justice system has copious laws, copious rules. And most of the time, you have to be a technical person to be able to navigate the judicial system effectively. By technical person, I'm referring to most often a lawyer. So if any of us has ever been embroiled in litigation, you understand what I'm talking about. It's what do you call it? It's common knowledge that you can lose cases, not because your case was bad, but on rules of procedure. That's how technical the area is. And because of that, litigation is costly. Lawyers do not come cheap. Legal representation is not cheap. Moving to the courts, getting your documents ready, putting your case together, your trips you'd make to the lawyer's offices, it's not cheap. So litigation is costly. And nobody likes cost. I don't. Litigation is also adversarial, because at the end of the day, the courts are not there to make you happy and make everybody happy. No, they're there to resolve the matter. And if it means one is right, one is wrong, so be it. That is justice. Because litigation is adversarial, one party has to win and the other party has to lose. So what that means is that litigating parties come out of the system with broken down relationships, right? And these are some of the failings of the formal court justice system, of the formal court system. Now, the court failings are not limited to civil matters alone. So far, you can tell from my conversation so far that I'm talking about civil matters. But the criminal justice system also has its failings. And the criminal justice system has been made weakened by several barriers to accessing justice. Right, so I'm going to look at some of the barriers to justice. And yeah, and I'm going to just talk about two, because there are a lot of barriers, but I'm just going to talk about two. So let's look at the first one, long delays. It sounds tautologous or repetitive, doesn't it? Long delays. But if you have been ever embroiled, let me speak for the Ghanaian criminal justice system, because that is where my expertise is. I'm quite experienced with the Ghana bar system, the Ghana legal system. Some delays are really long. Delays are inordinate. They take time. And it's a barrier to justice. Imagine that you have had your item stolen. You just want it returned. Or you probably want the person who took it to face some form of punishment. But you have to keep on going back and forth. You have to chase the prosecutor. You have to make sure that the statement has been taken. You have to make sure that the right person has been arrested. You have to it takes a lot of time. Now, let me go to the parent law, the 1992 Constitution of Ghana. It clearly stipulates that any person charged with a criminal offense shall here is mandatory, shall be given a fair hearing within a reasonable time by a court. Now, the 1992 Constitution does not define what reasonable time is. Therefore, it becomes subjective. What is reasonable time? Now, that vagueness, fortunately for us, is cured under the Juvenile Justice Act. So what does it mean? It means that juveniles are not exposed to long delays, because there's a specific act which says that juveniles must not be before their cases must not be before the court for more than 6 months. That's the law. But in my study, which I carried out in the juvenile centers in Ghana about 2 years ago, I discovered that 1 out of 10 juveniles actually has their case before the court pending for more than 6 months. And then the courts have still gone on to give judgments in respect of those cases. And some of those juveniles have ended up in correctional centers. So this is juveniles we're talking about, people who should be protected by the system. So you can imagine what happens in the case of adults, long delays. And that is a barrier to justice. I mean, what's the popular maxim? Justice delayed, justice denied. It is. Another shortcoming or barrier to justice is the inadequacies in existing laws. Like I started, the rule of law. No one is above the law. There has to be a certainty of law. Fairness, we should know what to expect. But when you have inadequacies in existing laws, which do not protect members of society, certain people in the society, then that's a barrier to justice. Because the offender deserves justice, but the victim also deserves justice. And I'll refer to the 1992 Constitution again. Now, the Chapter 5 enshrines fundamental rights and freedoms of citizens in Ghana. And within this chapter, there are certain values which are prescribed that the criminal justice system must uphold. You're talking about the presumption of innocence, the inviolability of a person's dignity, the right to a fair hearing within a reasonable time, rights to counsel, separation of juveniles from adults in custody, and so on. Now, if you listen to the examples I've cited, there's a trend. All these provisions in the Constitution, which is the supreme law of Ghana, are geared towards making sure that the offender's rights are not violated. But what about the victim? It's disturbing that the 1992 Constitution is silent on the victim, the rights of the victim. And it's not just the 1992 Constitution. There are other legislation which have the bearing on the criminal justice system of Ghana. I'm talking about the Criminal Code, the Criminal Procedure Code. They are all silent on the victim's rights. So what does that mean? The victim has been reduced to a mere observer. Criminal jurisprudence is limiting, at least in Ghana, the role of the victim to an observer, because it observes, it concludes or assumes that crime is an offense against the state. And of course, you can tell from the title, Republic versus John Smith, State versus Peter Smith. So it's the offense, the state has taken the offense. And that's why Niels Christie, one of the earlier jurists, would say that the crime is the victim's property and the state has stolen it. So with all this, victims in the criminal justice system often feel that they are left to fend for themselves with little auto support from the state. And they feel that the offender is protected at the expense of the state. So what are some of the possible effects of all this? Talk about 2, dissatisfaction with the justice system and overpopulation of incarceration. What happens when people are dissatisfied with the justice, like reprisals, instant or is a mob justice? And that is what we do not want to encourage as a state, which professes to have the rule of law. Another effect, and there are so many effects, but I'm just taking 2, is an overpopulation of the incarceration center, and that of incarceration centers, and that is a significant problem in the criminal justice system. I mean, these figures are there. They're just there, they are plain, and they tell their own story. There are more people in prison now than ever before. And ladies and gentlemen, unless a conscious effort is made by you as scholars, as academics, it's not going to get better. Now it's there. In 2023, 11.5 million prisoners worldwide. Let's not even go about that. I mean, 93% women, 7% being women, 93% men. Well, those are the statistics. And Ghana was at number 83. This research was carried out by the Institute for Criminal Policy Research at Birkbeck University of London. And in February, that's just about a month ago, this was the number of prisoners in Ghana. And our dear England and Wales came in at 24. This is how it is looking. Now, I'm not a statistician, and math is not really my strongest subject. But when I saw this particular data about the prison population rate, it had me thinking. Now, if you take 100,000 people in Ghana, 45 of them are in prison. Say 100,000, 45. But think about it. Wembley Stadium sits 90,000 people. Add another 10,000. So 45 of them are supposed to be in prison. You may think, well, that's just a drop. They've done things, they should be there. Okay. But when you compare it, and this is, Ghana is 33.5 million, well, as at February 2024. Compare it to Nigeria's prison rate. In Nigeria, when you take 100,000 people, 35 of them are in prison. What does it say? Stark reality. It should get us thinking. Does that mean that Ghana is probably, should I use the term, over-prisonizing people? We should be thinking about it. That is what it's looking like. Let me go to the website of the Ghana Prison Service. This was just this past Monday, and these are their statistics. Remand prisoners are 1,186, remand. Their cases have not been heard. Trial prisoners are 460. So I assume that trial prisoners means that it's ongoing, and the convicts are, of course, 13,000. Now, if you go to the Ghana prison site, it will tell you that their prison, the number of prisoners, the authorized prison population is 10,265. 10,265. And there are 14,000. If you do the math, 46% overcrowding rate. In writing that, I said, okay, all the statistics, okay, prison, what? I just had to remind myself about the prison's mission. But what are they for? What are they doing? What is their job? Humane treatment, reformation, rehabilitation, and reintegration of inmates. Rehabilitation, okay, so I'm thinking 14,991, excess of 4,726 prisoners. That is as at March, and every day, the dates, the numbers fluctuate because some people come in, others go out. Ghana's mission, Ghana's prison service mission is to reform, rehabilitate, and reintegrate them, to make them responsible. With this kind of figures on overcrowding, it's not happening. Now, Penal Reform International says that one of the key drivers, why do we have overcrowding? There may be several reasons, but I chose to focus on this one because this is where my work is going to. This is where I'm focusing on. Few alternatives to custody, few alternatives to custodial sentences, and also non-custodial measures. Oh, we know about it. There's so much noise about it. So much research has gone about it. But they're saying that things like probation, they may be there in our law books, but there's no adequate resources to roll them out. So with all this, I'm creating a picture here. I'm painting a picture to show you how dire our system is. So it's not working as it ought to be. Our criminal justice system is not working as it ought to be. And this is a reflection, not just in Ghana, but in several other countries. It's not working as it ought to be. Hence, my proposal. Why don't we look at a viable alternate means of addressing the needs of parties involved in crime? We are not just going to be looking at the offender, but is there any means? Is there any process, any viable alternative which would address not just the offender, but any other person affected? In my opinion, ADR is the answer. ADR, I'm teasing out victim-offender mediation. Why? What is it all about? Because it focuses on the parties. It doesn't leave one out. It focuses on relationships, restoring relationships, damaged relationships. I mean, when I started my research, one of the feedback I got, which I'm sure some of you may be thinking is, restoring relationship, reconciliation. Somebody has done something wrong. Is that the focus? Let's punish them. Put the key. Lock the person, throw away the key. It doesn't always work that way. Once we have elected to be ruled by laws, rule of law, remember, there are certain laws we need to adhere to. And one of it, which the Constitution says, is to make sure that we are addressing the rights of citizens fairly by abiding by the rule of law. We have mistakes, but we need to learn and move forward. So what am I proposing? Victim offender mediation, ADR. ADR is working. In Ghana, we have the ADR. I'll come to it. Let me not go ahead of myself. But we are saying it exists. ADR has made some inroads into criminal law, and it exists, and it's doing well. Let us think about it. So victim offender mediation, VOM for short, the examples in Europe where it has been adopted by a lot of states and it's changing their system. Right, and it's not just Europe, so I'm sure I'll probably have the reaction, okay, that's European, that's foreign, what's we want something local. What is going to work? Oh, it is working in South Africa's juvenile justice system. It is. And the reason why, I dare say, the reason why most countries have adopted it for their juvenile justice system, that's where it often starts from actually. The juvenile justice system is, obviously, if we do not protect the young people, who else? If we don't safeguard their interests, young people who have been involved in crime, who else? So most states have introduced juvenile VO and victim offender mediation, which is a form of ADR, which comes under the umbrella term of restorative justice as well, into their juvenile justice system. And for very good reason too. Let's look at the historical route. What is it all about? How did it start? But before I even talk about the historical route, shall I say it is in the name, victim offender mediation. What is it? We are bringing a victim and the offender together to mediate. Hence my question, negotiating with the enemy? Are we putting them on the table to talk together? Are we putting them in the same room to talk to each other about the offense? Is it necessary? Okay, so this is how it started about 50 years ago, where two young people went on a vandalism spree. They are Mennonites, and if you know Mennonites, a religious group in Canada. And the community was outraged. Vandalism, young people, of course, they had them, I think they were intoxicated. So they were deliberating, how do we deal with these people? And their probation officer got up in court and said, you know what? Why don't we let them speak to the victims? Let them see what they've done. Why don't we have a conversation with them? And that is what gave birth to the VORP, Victim Offender Reconciliation Project, which has metamorphosed into what we see today. What's the goal? The focus is to reconcile victims and offenders. Sometimes based on where we are coming from, and by coming from, I'm talking about African background, you're thinking, you want us to talk. He stole my property. He snatched my mobile phone. He violated he vandalized my car, and you want me to sit down and talk with him? Yes. Is it possible? Yes. Why? It emphasizes dialogue. Let's talk. It emphasizes accountability and forgiveness and reconciliation. Now, we're asking ourselves, but is it workable? You don't know you don't know some of these people. They're hardened criminals. Oh, we have so many arguments for them. But VOM actually has cultural significance. Yes. Victim offender mediation is very similar to what happens in our indigenous traditional systems. If you go to the chief's court, they have mediation there, a form of mediation, customary arbitration. Yes. And the reason why I'm saying that it is similar to what we do in our traditional areas in our homes is because the principles are the same. Look, before the advent of colonialism and all that, look, people lived in communities. And when somebody did something wrong, the community sat down. Well, the chief's court sat down. They called the person. They dealt with the person. There was no prison. There was no custodial sentences in our traditional justice system, no. But they had things as severe as banishment, I know. But they would talk to you. The idea was to integrate you back into society, get you to be accountable, and get you to do a form of reparation, if possible. And we're saying that those principles, underlying principles, are the same for VOM. We want to put the victim and the juvenile and the offender to have a conversation, to talk about what happened, and to make sure that the offender is accountable. So there are three things we say, not just me. The three principles are that 3 R's at the heart of indigenous system: reconciliation, reparation, and reintegration. And it's the same thing for the victim offender mediation. At the end of the day, we want to make sure that there's reconciliation. So by reconciliation, we are sitting down to talk about what happened, and it needs an active participation of the offender and the victim. And we believe that when this happens, there's a lesser likelihood of victim dissatisfaction or reprisal. Now, in the same vein, when we talk about reparation, it's not just limited to the payment of money or goods. No, it also includes a demonstration of goodwill. Sometimes it can be even a form of apology, but a gesture of good faith. which embodies the concept of restorative justice under customary law, reconciliation, reparation, and reintegration. Now, when the offender is made to be accountable, he understands what he did. He obviously give an explanation. This is what I did, so this is why I did it, whatever. When he's made accountable, he admits guilt, he faces his guilt, he's sanctioned actually. And some of these sanctions can even include an apology. I think I may have already said that. But they are imposed with the victim's agreement in the presence of community members. And this ensures the welfare and security of the community. So like I said from the beginning, remember the victim is not just only the person who has been harmed physically or had their items, but also their relatives, their family members, or people who came to their assistance. And they are part of the community. So those are the three parties in the criminal justice system. And like we said, the victim, the community, in the former criminal justice system, you don't really have a role. You're a bystander. The case is called, you come and give your evidence as a victim, and that's it. The prosecution is not going to ask you, how do you feel about this? Or what sanction? The court is not even going to ask you that, right? But we're seeing that in the victim offender mediation, this is what happens. The victim has an opportunity to express how they feel. They have opportunity to hear what the offender has to say, why they did what they did. It doesn't happen in the formal court justice system, and it won't happen. And also, we're seeing that this system, VOM, like the traditional system, it restores social relations in society, and it establishes new balances. At the end of the day, why do we even have a criminal justice system? Because we want to ensure that there's peace and development. And currently, the formal justice system is saying, let's lock them up, let's rehabilitate them. After that, we'll reintegrate them. Reintegration of prisoners into the Ghanaian society, that's a thesis for another day, how effective it has been. But we are saying that under VOM, which is similar to what happens in our indigenous traditional justice system, perpetrators take responsibility for their wrongful action. Therefore, sorry, I just got distracted by the interruption. So we've looked at the historical roots. VOM started from somewhere. It had a focus. And we're saying, look, it's not foreign. It's not foreign to us. It's not something we're borrowing from European culture. No, it's similar to what we already do. Now, the criminal justice is a creature of statute, remember. So therefore, nothing happens in the criminal justice system without a statute. So at this point, let us examine the legal framework, because I'm talking about VOM. Is there a legal framework? What is it? Maybe it already exists in the legal system. Let's have a look at it. So I'm going to start with the 1992 Constitution of Ghana. I've already talked about it. Chapter 5 enshrines the fundamental human rights of citizens of Ghana, inviolability of the person's dignity. Let me not repeat myself. I've said it. The Constitution doesn't talk about victims and their rights. Okay, so that's a negative already. That's a setback. Let's go to the Criminal and Other Offences Act. Like I already said, they do not, neither of those acts, Procedure Act, Criminal Code, they don't talk about victim offender mediation. They don't even talk about the victim. You're invisible. The victim is invisible. The community is invisible. Remember, it's the state versus the accused person. Everybody else is a witness or mere observer. Now, there's a new act which was passed about, it was 2022. The Criminal and Other Offences Procedure Amending Act introduces plea bargaining into Ghana's criminal justice system. Now, that is a welcome addition to Ghana's criminal jurisprudence. Plea bargaining. But it's not fit for purpose for victim offender mediation. Why? Two things. Why is it good? Why is it a welcome addition? Because it talks about possible compensation for the victim or restitution by the accused, which is a good thing. And also, it also tells us that, the victim must be informed by the prosecutor, not asked, or the opinion is you are informed by the prosecutor about the terms of the agreement. What terms of the agreement are we talking about? This is simple. Under this new law, a person charged with a criminal offense may, not shall, so it's not compulsory, may negotiate a plea agreement with the Attorney General or his representative at any time before the court delivers a judgment, may negotiate a plea, right? So it's the offender negotiating with the Attorney General, the prosecutor. The defendant, the victim is not part of this negotiation. What is he negotiating for? Lesser sentence, the different sentence or whatever. So I'm saying this act, good, 2022, we are making progress, but it falls short of the victim offender mediation standards. Why? The negotiation is between the accused and the state. The state is his prosecutor. That's not VOM. And the law even says that if he has a counsel, then the negotiation should rather be between the counsel and the prosecution. So the offender is even taken out at a point. That can be right. And the emphasis is on reducing the charge to a lesser offense. So new law, good, we are making progress. Like I said, it provides for compensation for the victim, which is good, but it's not fit for purpose. Let's go to the ADR Act. The Alternative Dispute Resolution Act was passed in 2010. So that means we have 14 years. My math, I got it right, 14 years. Fine, good. Allows for alternative, it's in the name, alternative dispute resolution, right? So let's look at certain salient sections of the law. Section 64(1) says that at any stage of a matter, the court may, so it's not compulsory again, it may refer a matter for mediation. So the court does that suo motu on its own accord. Or I think under 64(2), it says a party to the action may apply a notice that the matter should be referred to. Now, the problem with this section is that it says a party to an action may apply to the court. 64(1) says that the court can do that. The problem with it is that when it comes to criminal matters, only the accused and the prosecution are recognized as parties in criminal proceedings. We said Republic versus Kojo, Republic versus Smith. Only the accused person, only the accused person and the prosecution are parties. So what does it mean? It means the victim cannot apply section 2, under subsection 2, cannot apply for the matter to be referred to mediation. At best, the prosecution may do so on behalf of the victim, but the victim cannot direct the prosecution on how to handle the case. So, and then if you read subsection 3, it says that a reference to another section will state the nature of the dispute, monetary value. Those words, those terminology points towards the civil matter. What does that mean? It means that it is the lawmaker's intention that the ADR Act, that this should be a civil reference, the matter which can be referred to mediation under section 64, I say 64, yes, is a civil matter. So criminal matters are excluded. Then let's go to section 89, which for me is quite important. It tells us that, I'm sure it's a bit late, I'm hoping you can read it, the writings are a little here. Right, so it tells us that, let me just rewrite, the person, except ordered by a court, you cannot submit a criminal matter for customary arbitration. Now let's take a step back. I did say that what happens in our traditional justice system, which we call customary arbitration, justice at the chief's court, it is VOM. It is a form of victim offender mediation. So if you have any law which refers to referring matters to customary arbitration, that's what we want. But this law is telling us that you cannot submit a criminal matter for that. There. But so when you read it and the first reading, it appears to make it impossible to refer criminal matters to traditional rulers to be resolved. However, if you read it as we say in the legal parlance, upon proper legal construction, when you properly interpret the section, the line says that except otherwise ordered by court and subject to any other enactment in force, a person shall not, except otherwise. So it means that the Act places 2 condition precedents that must be met for criminal matters to be referred to criminal arbitration, to customary arbitration, I beg your pardon. First, the court must order the criminal matter to be submitted for customary arbitration, and 2, there must be no law that prevents such an order from being made. So it's good. It's good. However, could we just have a law which makes it much more simple? Because the second condition precedent is a bit, that's tricky, because it says that there must be no law that provides such an order for me. Let me read the legal one. It says, subject to any other enactment in force. So can you imagine that the court is sitting here in a criminal matter, is thinking, oh, this matter should be gone, you can go for VOM, customary rehabilitation, he's about to do it. Then the lawyer on the other side, who is obviously opposed to it because they know where they're going, says, no, there's this law which says this matter, and then they pull some law which we don't know. We are saying, please, the ADR needs to be amended to reflect modern reflective practice. That's what we're asking for. Then let's go to the Courts Act, which is another very important section, a very important legislation. And so far, I dare say that seems to be the most favorable, favorable legislation, which is predisposed towards VOM in Ghana's criminal justice system. Section 73 says that, let's see, a court with a criminal jurisdiction may promote reconciliation. What does it mean? It means that this language it uses here, this is the VOM language. This is what we want to see. It says that a court with criminal jurisdiction may promote. It says may. We'll take it like that. We would have loved shall, but for now, let's work with me. This is what we have. We'll work with it. May promote reconciliation, encourage and facilitate settlement in an amicable manner of any offense. Then there's a caveat, which is not a felony or it's not aggravated. Well, like I said, baby steps would accept it, on payments or compensation or other terms. Bottom line, it says they can do the end made during the pendency of the negotiation for a settlement stage, the proceeding. What it means is that at any stage of the matter. So if the court feels, you know what, this criminal matter, I mean, this is, you stole a goat. You didn't steal the farm. You stole some plantain, you stole some yam. You didn't dig up the whole farm. I don't think you should go for, you know what, let me refer you to customary arbitration. Go and talk about it. See if you can make some restitution or compensation. The court can do that. But the only, which is good, and that's it, we love this because this is VOM, this is VOM language, which we want to see. But the only drawback is, can a victim or offender apply for the matter to be referred to mediation? Because the law says that any court with criminal jurisdiction may, like you said, only accused persons and the prosecution are recognized as parties in criminal matters. A victim cannot apply for a matter to be referred to mediation. So this is good. Like I said, baby steps, we'll take it, but we could have something better. And something better is here. The Children's Act, which I said is also a good thing because it means that Ghana is thinking about the next generation. Now, Children's Act provides for, it's there, black and white, there shall be an establishment of a child panel. What will they do? They will have non-judicial functions to mediate criminal matters, civil, which concern a child. This is what we want. And when you read the word in Section 32 of the Children's Act, it's there. Child panel shall assist in victim offender mediation in minor criminal matters. 1998, this law was passed in 1998. In 1998, the Ghanaian lawmaker had heard of VOM and thought, let's put it there for the children, which is good. We are happy. And of course, it goes on to tell us they can put in an apology, which is good. But we are saying, can we extend it to the general criminal justice system? Should we? Maybe if we had more research on how effective the panels have been in the juvenile justice system, maybe it'll be a good case. Right. So with all this, we are still thinking, are you still saying that we should negotiate with my enemy? And I'm submitting that it is a possibility. It's not just a possibility. It is something the Ghanaian legal justice system should be thinking about. Why? Because ADR in Ghana's criminal justice system has potential. It has potential. The first thing is that it empowers the parties to navigate the criminal justice process. Like I said from the beginning, if you have ever been embroiled in the justice system in Ghana, I mean, the civil justice system is quite grueling on its own. I can imagine being embroiled in the criminal justice system as a victim, worse offender. I've been a practitioner for quite some time now, and it is not easy navigating the criminal justice system. Why? Because, I mean, I already talked about it when I started. The system has barriers, and these barriers can, in my opinion, be overcome they can be overcome if we adopt ADR. Why should we do so? One, because the victims have a need for reparation. I know when the victim goes to court, I mean, they see the accused person, they're upset, they're angry, you stole my property, you did this. But why are they there? Yes, they want to see punishment, but they have a need for reparation. Reparation means some form of compensation. Remember that we've said that the victims mostly feel that they have been left to fend for themselves, whilst the offender is protected at the expense of the state. And can you blame them? The offender has a right to legal aid. The victim doesn't. Somebody said, does the victim need legal aid? They do, because they are parties to the criminal justice system. And we are saying that the criminal justice system often overlooks issue of compensation to crime victims. There's been talk about it, but currently we don't have it. The other advantage or reason why we should be thinking of including ADR in Ghana's criminal justice system is because it includes the victim in the process. It emphasizes the victim. What does the victim need? The victim needs healing. The victim needs healing. And remember the definition of victim we referred to at the beginning. Healing is not just only, the victim is not just the person's property has been damaged, but the victim also includes the person who went to help the primary victim. All those people are victims. And they have harms whose needs are very, very rarely met by the formal justice system. The victim needs to be included because they need to know what to expect. They need to know after the perpetrator has been apprehended, they need to be informed. And Sharp, one of the victim jurists, says that is known as the victim's need for information. Sometimes being kept in the dark alone can be pretty upsetting. Upsetting doesn't even describe it. It can make a victim become disgruntled easily. And the victim also has a need for vindication. And ADR does that. Vindication in that there are psychological benefits for the victim, the process, because the victims need a place to express their anger. And sometimes that's really what they need to do, just express their anger towards the offenders. The formal justice system does not allow the victim to describe. Can you imagine the court of law, as we know it, then the judge say, yes, Mr. John, your item, can you tell us how you feel? Then Mr. John mounts the witness box. I feel hurt, There's no place for that in the formal justice system. It doesn't happen. But we say that it's needful. It's psychological. Some of these victims have to go through therapy because of what they've suffered at the hands of these offenders. And yes, a guilty plea very well may result in a sentence, but it doesn't give the victim the vindication they need. And it's even
I'm sorry, Dr. Izac-Hassan, just to update you on your time, you have about 10 minutes.
All right,
thank you. To wrap up things for us. Yeah,
right.
Thank you so much.
Thank you very much, guys. And we are saying that the system on the ADR also holds offenders accountable for their actions. Why? Because a fundamental principle of VOM is that offenders must face the fact that they have broken the law. They have harmed some people, and they should be made aware of how their actions have damaged others. It also gives them the opportunity to explain themselves. Why did you do this? And then also repair the harm which has been caused. And quite importantly, ADR within Ghana's criminal justice system will help promote effective case management. I mean, if you've been keeping tabs on following what happens in Ghana, we know that about a week ago, there was a directive from the Chief Justice that certain courts are going to go on shifts. Some courts are going to be sitting as late as 6 p.m. to clear a backlog of cases. You have over 600 cases pending in the court. And we're saying that, look, let's take some of this out of the system by introducing ADR. But it's not a perfect system. There are some drawbacks which we must acknowledge. And some of them are the potential source of secondary victimization. It's possible. I mean, you're putting this victim in to face this accused person. Sometimes the conduct of the offenders may actually render the process nugatory. He may be unwilling, they may be unwilling to show remorse, which can also infuriate or exacerbate the negative feelings the victim is already feeling. And some offenders might even rationalize their behavior, which can be quite annoying. So this is some of the drawbacks, right? Imagine a burglar blaming the victim for having a weak security system. That can be annoying. And then another drawback is that there's a misconception about victims' interest in criminal proceedings. Some juries believe that, like I've said, I believe, oh, the victim wants to be involved, get them involved. But sometimes some victims feel that the punishment is enough. That's it for it. And sometimes they may even be disruptive to get them in. And during the research I carried out, I realized that the needs of the victims of juvenile crimes and persons who are affected by those harms are not met. But I realized that some of the victims I interviewed preferred that those young assailants should be detained in a correctional facility. So this misconception is a reality which we cannot throw away. And then also, VOM is voluntary. It says the court may. It's a voluntary, and you can't force someone to negotiate. So that can also be a drawback, right? And then, of course, there's a myth that it addresses the victim's feelings. Sometimes it doesn't. Some people, they'll show up, then they won't participate as you expect them to. But I believe that the appeal of mediation is evident in the satisfaction of victims and offenders with the process rather than with the courts for various reasons. Yes, the courts are, it has potential benefits, I know. And like I said, it's less, the process is less expensive than the court system, and crime victims are more likely to receive apologies. So let's go to the final point. How do we implement it? We've said, let's let them negotiate, let's let them talk. How do we do so? Implementation and monitoring. What do we do? 3 things: legislation, training, advocacy. Legislation, what do we do? Let us regulations which reflects modern justice practice. In other words, let's have legislation which outlines VOM as a suitable dispute resolution practice, right? Introducing provisions in our laws which will facilitate the making of reparation and alleviate harm caused by offenders, strengthens the victim's position in criminal procedure. Training. I realize the ADR training has been incorporated into the law school in Ghana since 2010, which is a good thing. However, I believe that the awareness and effective professional practice of victim offender mediation, which is a form of ADR, should be done by members of the legal fraternity. The knowledge amongst them is not widespread. So I'm proposing that there has to be an emphasis on continuous legal education for members of the bench and the bar on the need for adoption of ADR practices into the criminal justice system. And finally, advocacy, like this, platforms like this. Let's write papers, let's do our research, let's talk about it, let's carry out some civil education among members of the public. Let's create their awareness. Negotiating with the enemy, is it possible? Oh, yes, it's possible. Why? Because it's wholesome. There may be some drawbacks, but it's important and it has the potential to improve our criminal justice system. That's all for now. Thank you so much for your time. Thank you.
Thank you very much, Dr. Elizabeth Izac-Hassan. Thank you so much. That is very insightful. We have about 15 minutes for question and answers. I'm really sure that after such a very good presentation, participants would have a few questions to ask. So please feel free, if you have any questions, you may use the icon to lift your hand, and I believe Dr. Izac-Hassan has a few answers for us. The floor is open, please. Yes.
Sorry, I can't
yes.
seem to find the icon to lift my hand.
It's fine. Brilliant. It's fine.
Elizabeth, thank you very, very much for sharing your research. Just a few comments, because you said you were hoping to get some constructive feedback.
Yes.
So I am an arbitration specialist. And if you look at I've written on the Ghana law. So if you look at section 1 and 5 of the Ghana ADR Act, it is very clear that it is for it applies where you do have private rights that you can dispose of, and that's across the board. So it's to think about it. What you're basically talking about is restorative justice. There's a clear reason why it is called restorative justice. Mediation cannot be a right descriptor simply because of the definition of mediation. And when we talk about mediation, you're thinking of parties that have some degree of power balance, because it's the parties themselves that are making the decision. The role of the third party neutral, the mediator, is to help the parties engage and talk to each other. There are different types of crimes. So I think that it's important to go back to the philosophical underpinning of criminal law, which you would know much, much better than myself. And the fact that there is a reason why it is the society, it is the public that an offender offends. That is critical because that's fundamental to our understanding of criminal law. And so it's not the victim that is the primary recipient, if you like. It's the whole community, so that the state represents the whole community. So I think it's important to sort of unpack that and come back to the point you've been making, which is, well, where is the victim in all of this? I think that's an important point, which is what underpins restorative justice. The second point is that you've done some work with young offenders, but young offenders and adults are not the same. And that is critical. So there is, I can understand, I think you can sell the idea of restorative justice going back to the laws that you shared with us on what are the penal institutions there for, to reform, to restore, to reintegrate offenders. So if they're young people, there's a stronger case to be made for restorative justice. It cannot be mediation because you're not mediating, you're not engaging in a negotiation with the criminal or the offender. So I think it's important to rethink the use of the word mediation and maybe to just sort of follow through with restorative justice. And then if you think about it, under customary dispute resolution, is not all forms of customary dispute resolution processes that are customary arbitration. We have clear definition of what customary arbitration is. Incidentally, the old West Africa Court of Appeal has lots of Ghanaian cases where customary arbitration is clearly defined. I think that's important, just so that we're clear with what it is we're talking about. So I think it might be useful, instead of sort of trying to reinvent the wheel by using mediation, to fall back on restorative justice. The work being on restorative justice, especially looking at what we call misdemeanors. Felonies you can't be raped by somebody and you're expected to sit across the table from somebody who raped you. You can't. And so it is understanding, I think, maybe starting with the lighter, especially with young offenders, because it's clear why they need rehabilitation. They have, their whole lives ahead of them. We want them to become proper, good citizens, blah, blah, blah. But to go back to the correct terminology, which is restorative justice, and to take out that the mediation point. I think the point you make about going back to traditional means of resolving disputes, I think is really, really important. And maybe to just take it back from the literature so that it didn't start in the 1970s from Canada or wherever. We had this, and there's lots of literature already on traditional forms of dispute resolution. Again, Ghanaian colleagues are quite strong on publications in that, on traditional dispute resolution. And what you would get is that the underpinning reason why we were more, if you like, reconciliatory on the traditional forms of dispute resolution is that integration, is that community, the sense of the community and the sense of communal wholeness. So I think you have a lot already, but don't make it too sexy by adding the word mediation, because then it becomes a huge problem, because it's not mediation, howsoever it is conceived, it's not. Yeah. So but I thought that was very, very, very good and very helpful. Thank you very much.
Thank you very much, Professor Emilia. Thank you.
Yeah, thank you very much, Professor Onyema. Dr. Izac-Hassan, would you want to make any responses to that before we take the next question?
Professor Onyema has said it all.
Right.
Just pick up, yes, what she said. Yes,
Excellent.
thank you for that. Yes.
Thank you. So do we have any further questions from participants? We still have some time for question and answers.
Can I come in?
Yeah, please.
I mean, the sign to actually raise the hand is not there, so that's why I'm just beginning to speak directly.
It's fine. It's fine.
So, Elizabeth, thank you so much for your insightful presentation, and I just want to add a comment. It's an observation from your presentation, because you did highlight it by going back to the relevant statutory provisions that deal with issues of that deal with issues of arbitration, where the court may actually refer matters to arbitration. So in that context, can we say you made references to the Courts Act 1993, the Children's Act 1998, then the Arbitration Act. So can we then say that arbitration more or less already exists partially, or already exists within the criminal justice system, but only needs some kind of improvement? To that extent, if that is the case, then are we talking about enhancing the current existing regime, or we are looking at the potential of deploying ADR, as the title communicates to us? Are we talking about is non-existence, and we are seeking to deploy or making a case for its deployment into the criminal justice system? Okay. I don't know if my point.
Thank you very much.
Yes.
Yeah.
I think I understood you. If you're asking, and what I picked out, whether arbitration already exists within the criminal justice system.
Yeah.
That's what I understood you to be asking.
In relation to juveniles, the Children's Act made a provision which you made references to.
Yes.
Yeah.
Right. So like I said, no, it's not arbitration. Like I said, the juvenile justice system, Ghana's juvenile justice system, admits of a victim offender mediation. So under the Children's Act. So the victim offender mediation simply means that we refer the parties to the child panels under the Act to mediate between the offender and the accused person. That's what exists. And by working, the statutes I walk through simply to let you know that the criminal justice system does not have arbitration. Arbitration doesn't exist with the criminal justice system. No, it doesn't. But this, my research is to create the awareness about the lack of an alternate dispute resolution, to create a lack of an alternate means of resolving crimes or dealing with crimes in the criminal justice system which I'm proposing should be done under victim offender mediation. But of course, Amelia has talked about the emphasis on mediation being different. But yeah, victim offender mediation, that's the term used within which is a restorative justice process. It comes under the restorative umbrella term, which to propose that we should rely more on that. But arbitration as itself, no, it doesn't have a place within the criminal justice system. I don't know if I've answered your question. Okay.
That is correct. So, I mean, the point I was just making was ADR in general, that alternative dispute resolution mechanism already exists in the system. To that extent, are we talking about enhancement or freshly introducing that into the criminal justice system? Okay.
Let us introduce it into the criminal justice system. In its form, VOM as a restorative justice practice, which is an ADR, exists within the juvenile justice system, which is part of the criminal justice system, is an aspect. But I'm saying let us broaden it, let us expand it. ADR, criminal justice system. Yeah.
Thank you so much. And thank you for your exciting presentation.
Thank you.
Thank you both. We have Kezia. Kezia, you have your hand up. Yes, Kezia, go ahead.
Hello, good evening, everyone.
Good evening.
Dr. Hassan, thank you very much for your presentation. I was your student in first year, KNUST Faculty of Law. Yes, you took me to buy porridge. So that's, I don't know if you remember me, but yes. So my question is, in your final words, when you were suggesting that the judiciary, the stakeholders, the lawyers be involved or sort of sensitized into doing more of this VOM, mediation, etc., etc. I didn't hear anything about the politicians and legislators, because at the end of the day, it boils down to them. They are the ones that are making the laws that are either restricting or adding the mediation into it. So how do we add them or fit them in to buy into the idea of victim offender mediation? That's my first question. And your answer would give me the follow-up. Thank you.
Thank you so much, Casey. And yes, I do remember you from the Faculty of Law first year. I remember you. Right. So my first point I made on as to how to implement ADR was legislation. That's what I said. And I said that legislation has to be passed. Legislation which takes into consideration or into consideration relevant ADR practices which have a bearing in the criminal justice system. What I didn't spend my time saying was the legislation will be passed by lawmakers. And so when I tie that in with my final point on advocacy, of course, we need to make advocacy. The message has to be sent out. It has to be clear that this is how the world is going with our criminal justice system. This is what we want. And obviously, then the legislation will be passed by the lawmakers. So yeah, I hope I've answered your question.
Yes, please. Thank you. So then now the follow-up to that is, how then do we streamline the system? Because with criminal law, it's basically the prosecution standing in because they believe the victim cannot defend themselves, or the victim do not have, should I say, quote unquote, the means to stand up for themselves in court. But more often than not, we seem to see, we get to see the, should I say, abuse of power. There are some complainants who come and report the case all right, but later on they draw back and say, oh no, I don't want to prosecute the case anymore. Let's just end it there. But the police still take it up and say that now it's in the hands of the state. So we are going to continue with it. And that is where I am sort of having an issue. If we are even going to introduce mediation, who are those who are going to be in charge? Because the very people or the stakeholders who do all of this, they tend to abuse that power. So how are we going to harmonize all this? Yes, thank you.
Thank you, Kezia. So, Keziah, so I beg your pardon. So, yes, and this is where my research has been. Actually, my research focuses on relying on indigenous systems to carry out victim offender mediation. It's not mediation, it's victim offender mediation. That has been my research, but I didn't focus on that tonight because I just want to talk about introducing that in criminal justice system. But my proposal has been that we have a system, we have the chief's courts already, they're existing. Let's just legislate to bring them into the system, as it were, a hybrid system where the courts will refer matters to the chief court and still continue to exercise the supervisory jurisdiction over it. They are already laid back. It's forever, not forever. They are not going anywhere. They adjudicate cases. So if we are confident with the systems, the traditional systems on which they rely on to adjudicate cases, let's just probably just train them in modern judicial system, maybe the use of IT, the recording of cases, because those are some of the drawbacks in the traditional court system. But my proposal has always been, let us rely on judicial indigenous institutions to facilitate restorative justice practices, one of which is the victim offender mediation. Of course, going forward, there may be other groups which you may, but for now, my focus has been the traditional institutions are capable. Let's create a hybrid system where we refer the cases to them, keep like I said, the court maintains a supervisory jurisdiction over them so that they report back, there's properly recording, and then, then we carry out restorative justice within the criminal justice system. That has been my proposal.
All right, thank you very much, Doc.
You're welcome.
But what law would they be using?
Legislation, madam. That's why I said legislation. So it all starts with, that's why I said the justice, the legal system is a creation of statute. That's where it starts from. So when I say let's have proper legislation, that's what I mean. It starts with legislation. It's a creation of statute. Let's pass a proper law. We have the ADR Act, which, as it were, regulates the use of ADR mechanisms to adjudicate matters outside of the courts. Let's have a similar, or let's have an amendment to that law, which includes criminal matters. We can, fine-tune all that. Legislation, it starts with legislation.
Most grateful, Doc.
Welcome, thank you.
All right, thank you very much. We have Dominic next. Dominic Obing, please go ahead.
With regards to the traditional system obviously being a part of the mediation process, my worry is about uniformity and standardization. The fact that for certain offenses, somebody could be fined, a bottle of schnapp. Another one may have to, present 10 goats, for the same thing. So I'm kind of wondering how we standardize and ensure some level of uniformity and also minimize abuse. And the fact that when it comes to redress, traditionally, whatever compensation is presented to the chieftaincy system has always gone towards the chief rather than any victims involved. So that's where I have a little query. Maybe you can shed some light on it.
Okay, thank you so much. So as I said earlier, legislation, in my opinion, will cure the mischief. Now, what I proposed in my research is that we'll have a hybrid system where we have the chief's court mediating matters which have been referred to it by the court. So this is what happens, just like now, Republic versus the state. The person is put before the state, but the legislation which is in place has already said this type of offenses which can be referred to the chief courts. And when we have such a system in place, so the matter is called, it's referred to the chief's court, the main courts retain supervisory jurisdiction. What happens is that whatever happens at the chief's court happens, and then they report back to the main court, which has to enter it as, the process is complete. Now, in so doing, by retaining a supervisory jurisdiction, it means that they have the right of review, they have the right of appeal. So if there's anything which went on at the chief's court which was not appropriate, or like you use the term standardization, it will be up to the main courts, the formal courts, to make sure that things are set things are set aright. By set aright, I'm just trying to make sure that there's some uniformity. But of course, let's not forget that what happens in community A might not be the same as community B. So yes, someone has stolen a goat in town A. The person was asked to replace the goat. Someone stole a goat in town B. You're not asked to replace, but we're going to work for the person. At the end of the day, what is the focus? The focus is to make sure that there is appropriate reparation and that the party is reintegrated. So that may mean that there'll be some discrepancies, shall I use the word discrepancy? Yes, in what happens in community A as opposed to community B. There'll be some differences, yes. However, at the end of the day, it's justice which must be served. So if it takes you going to work for the victim for 3 weeks, for there to be reconciliation, appropriate reparation, and reintegration into the community, that's what works for community B. That's fine. If what it takes for community A, because remember, it's a victim offender mediation. Victim here, offender here, they are talking. This is what you did to me. This is what I didn't like. You stole my goat. You said you didn't have it, blah, blah, blah. They go back and forth. Then the mediator, who is the chief, is sitting there and says, okay. In this community, this is what we do. You have to replace his goat with 3. This is with 3 goats. That's what we've agreed on. And then it's carried out. So at the end of the day, we make the parties reconcile and be reintegrated into the community. That's it. But because we still have the case hasn't been taken completely out of the criminal justice system. No, the courts still exercise supervisory jurisdiction because they have to report. So the court is like the big brother, making sure that the rules of law have been applied, there's been no abuse, and as it were, the excesses are being kept. I hope I have answered your question.
Thank you very much. Thank you very much. I think you have. I also
Thank you very much. We have a question in a chat box, so I'll quickly take that, Dr. Izac-Hassan.
Yes.
This is from Birago Amufa. Question is, did your research look at categorizing case types that can be dealt with using ADR? And yeah, so yeah.
Yes, thank you for your question. Yes, my research looked at that because there are certain cases which are not referable to ADR based on the practices. But then again, you have proponents who feel that certain cases can still be referred to ADR. Let's go to the Juvenile Justice Act. It's clear, Ghana Juvenile Justice Act, which allows for the reliance on the victim offender mediation. It says that you cannot refer a matter to victim offender mediation where it's a serious offense. And the Act stipulates what a serious offense is. It listed piracy, rape is there. So the Act is there. So yes, my research looked at the cases which can be dealt with using ADR. But just to throw more light on that, there are some there are proponents who feel that serious cases are rather the purview for restorative justice because they feel that that is where the impact is felt more. So it's an argument, it's going back and forth. And I mean, it's an argument, you have proponents for that. They also feel that, look, based on the statistics, maybe you have more, you have serious offenses, not so minor offenses, that's what the Act calls it. Let's deal with those ones. What is at stake is less. Let's deal with those ones so that they can, they can leave the system, unclog the system. But like I said, others also feel that the impact of restorative justice will be felt more. So yeah, that's the argument.
Thank you very much. I think it will be good for me to play the devil's advocate here. Probably that will be the last. So I was just thinking, looking at fairness and looking at the fact that we are looking at VOM. So the emphasis is on offenders. Is there any capture of re-offenders in this?
As in, you're asking whether or not people who have offended and yes. Offenders is offenders, term of art. So we don't look, and that's actually one of the imports of VOM, to reduce recidivism. So we are not, when the court is referring you to the process, we are not asking, are you a third? Maybe if you're a recidivist, that's the more reason why you need to be referred there, actually. So offender is used simpliciter. You're an offender, we're referring you there. You've offended, in this case, we're referring you to that, that's it. I answered your question.
Thank you so much. I am very convinced that that should bring us to the end of our session. But a few announcements before we bring the curtains down. Our next seminar presentation will be on the 24th of April, and we are asking and requesting everyone present here that please do send through your presentations, and we'll be happy to put you forward for one of the seminars for you to present to us. We are still open for presentations. I think Dominic Obing, you have your hand up.
Oh,
Unless it's
sorry,
gone down.
I've already asked my question.
Right, okay, thank you very much. And also, registration for our upcoming conference is also opened. The deadline for submission of papers is on the 31st of March. So please, if you have any paper to present at the conference, please do send them through. Remember, the conference will take place from the 19th to the 21st of June. And please, if you haven't registered, head to the website and put in your registration. I think the conference fee is £100 only. So in the absence of any other question, if we have Dr. Adams here, please, would you have any final remarks before we bring the curtains down? In the absence of that, we want to say a big thank you to Dr. Elizabeth Izac-Hassan for your very interesting presentation. We really appreciate you being here to give us that insight on the ADR system in Ghana. We really appreciate your presentation, and thank you to all for also joining us for this program. As I said, the next one will be in April, and we will look forward to seeing all of you here again. Thank you so much. Thank you.
Thank you so much, Dominic, for an excellent work done too as well.
Thank you.
Elizabeth, thank you. Yeah.
Thank you.
Thank you. Thanks for the invitation. Bye.
Bye.